Okay, folks, good afternoon. I'd like to call the Records and Public Safety Committee meeting to order. Hold on, before you folks stand up, I know it's a little on protocol. We're going to have Commissioner Sauger make a dedication and statement. Go ahead.
Yeah, as you all know, today it's 75 years with D-Day, and it's quite a celebration. But also I want you to remember, probably most of you do not know what the lobby is named after downstairs, and that is Walter Wetzel, who was a private from city of Roseville, fell under a hand grenade during the Second World War. They posthumously gave him the Medal of Honor, and he's the only one from Macomb County. And that's why this lobby was named after him in, I think the year was 2000. You were here, Don, I think. Bob, you were here. The year 2000, that's what it's named after. So just a little bit of information to keep in mind how he got that name. Now we got a park named after him up there in Lennox Township, and I think there should be a big plaque put up there who he was and what he did. But he was quite a hero, and thank you.
Thank you, Commissioner Sauger. Commissioner Hall, you want to say something?
Yes, thank you, Chairman. We also named, as he was a Roseville resident, as Commissioner Sauger said, the drive in front of City Hall after Walter Wetzel. So thank you.
Commissioner Kleinfeld?
Thank you. I recently looked this up. I don't know if anybody here knows what the D means in D-Day. And it does. It means day. So it's day. Because the military will say, they'll say day, this is the day we're going to do something. So there will be D-1, D, and then D+1. So D means day. D-Day. I just, in case any you guys, I'm assuming most people didn't know that. Thank you.
Well, thank you very much. All right.
Just have to
Commissioner
put in,
Majek.
yeah, when we talk about D-Day, the only person I know personally that really I ever met was our late Commissioner Leonard Haggerty, who was D-Day, and I got to know Leonard as much as I could over the years and learn about his stories. And he was on Omaha Beach. He was also, he was in the Army, Omaha. He was a bodyguard for Pat. Well, I was going to get to that. So we're at D-Day, Normandy, Omaha Beach, the Battle of the Bulge he was involved in. Obviously, the inward fight towards Berlin. He helped to liberate Dachau concentration camp and was a motorcycle driver for General Patton. And he told me, in his words, yes, General Patton was an SOB. And Leonard's, if you knew Leonard, you know how he was. And he told me one time, he said, Bobby, at the end of World War II in Berlin, there was not one roof standing, you know. So when you hear that, and he had other things that I'll tell you off to the side that he talked to you about, but a lot of these veterans and people are gone, so I'm just blessed and lucky to have met him. And one more thing. My wedding anniversary, we had 20 years yesterday, but 20 years ago was my wedding. Leonard came to my wedding, and my uncle from Europe came also. And that was interesting because I introduced Leonard, who was World War II, with my uncle, who was 15 years old when he fought in the resistance in Europe. And I got them together to meet, to have a little small talk. That was very special for me. So thank you, Mr. Chair.
You're welcome. Yes, go ahead, Commissioner Brown.
Since we're reminiscing, you know, there are many interesting stories, and some of them were compiled here. Macomb County helped produce a cable show with then Congresswoman Miller. It's called the Veterans History Project, which is done in conjunction with the Library of Congress. And you can go on the Library of Congress website and find the Veterans History Project. And in it, they've got just catalogs of, probably by now, thousands of videos from testimonies of actual people that served in various conflicts overseas, and obviously we're talking about World War II, and they're right from the veterans' own minds, or their own words rather. And so it's interesting that so many of them have passed on, right? But they took the time to record it, as we did here in Macomb for our little vignette. We had some from each of the various wars that we went through, but the World War II veterans are becoming short, and but their stories are preserved forever in the Library of Congress on the Veterans History Project. So if you're looking for something to do, check it out. Thank you.
Thank you. If there's nothing else, I think we should do the next best thing, is Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, before I seek a motion to adopt the agenda, I just want to make one note of change. Under 9A, B, and C, there is an amendment that's going to be requested. The attorney's name is Mark Pizer. That name is going to be replaced with attorney Christopher Trebelak, I think I'm saying that right, from Clark Hill. So if you take a look at 9A, B, and C, remove the name Mark Pizer, and basically just add Clark Hill and Trebelak, Trebilcock. With that, I'm seeking a motion to approve the agenda. Commissioner Sauger, supported by Commissioner Hall. Please vote. Okay, the motion passes 13-0. Moving on now for an approval of minutes. This is for the fund motion, or the fund hearing on April 10th, 2019. Seeking a motion to adopt the, approve the minutes. Commissioner Kraft, supported by Commissioner Drollet. Please vote. All right, that motion also passes 13-0. Public participation. This is where I have anybody from the public come up. You got 5 minutes to talk about anything that's on the agenda. If you wish to do so, please come up, introduce yourself, and give us your address as well. Anybody? Would you like to come up, sir? Come on up. It's got to be for something on the agenda, though. Okay. There's a little button there. If you could press that so we could hear you. Mic should turn on. Right there. Yep. And go ahead, state your name and address, please.
Thank you, Your Honor. I'm sorry.
No.
Thank you, Mr. Chairman. My name is Robert Davis. I am from Highland Park, Michigan, in Wayne County. I rise to speak this afternoon because it's very interesting that you make the amendment, suggested amendment, adding to Item 9C, an individual by the name of attorney Chris Trebelcock and Clark Hill Law Firm. In reading the public documents, and I appreciate this honorable body having your board packets readily accessible to the public on your website, because the information provided reveals that your ordinances as well as your charter are currently being violated. Currently, right now, even as of 15 minutes ago, the Clark Hill Law Firm has filed various motions on behalf of the Macomb County Prosecutor in a pending civil action in which the Macomb County Prosecutor is not a party. So I am puzzled that you have an ordinance that states that a contract is not valid unless it is first approved by this body. But yet and still, you have an unauthorized attorney and law firm who are currently filing multiple motions and seeking to file actions in which they are a non-party on behalf of Prosecutor Smith. So my question to this honorable body is that since you have proof, and I ask that during your closed session, the name of the case is Robert Davis versus Macomb County, pending before the Honorable Judge Fonts, in which Mr. Trebelcock and Clark Hill, nearly a week and a half, 2 weeks ago, filed an appearance on behalf of non-party Macomb County Prosecutor Smith. And it's a FOIA case. It's a FOIA case dealing with the search warrants and inventory lists that were served upon the prosecutor's office nearly a month ago. The county had entered into a stipulated order to settle the matter in order to save the county taxpayers money because the FOIA statute was clearly violated. And the documents that were requested are clearly public documents under the statute and under established case law. So my question to this honorable body is, why is it that Prosecutor Smith and this Clark Hill law firm, which I'm very familiar with, are violating, or blatantly violating, this county's charter and its ordinance. Now, if this particular matter, which is item number 9C, and mind you, I want to state for the record that this law firm misrepresented the truth to the Honorable Judge Fonts at the last hearing that was held in this matter, which was just held this past Monday, in which they misrepresented to the court to state that they were seeking approval from this body to get approval to represent Prosecutor Smith in my pending FOIA lawsuit against Macomb County. Item number 9C does not reflect that. Item number 9C states that they are seeking, meaning Prosecutor Smith, is seeking independent counsel for the purpose of filing an independent action against this county. That would not achieve that purpose in my pending lawsuit. They would have to intervene as a
Just
defendant.
to let you know, I'm going to give you about a minute to wrap it up, okay? All right,
Thank
thanks.
you.
I'm going to act like a judge. That's what they do
No,
to
no.
me. Yeah, I got it. All right. Yeah.
Thank you, Mr. Chairman. They would have to, Mr. Smith would have to intervene as a defendant and not a plaintiff. And one thing I appreciate about this county's charter is that your county charter is very clear and unambiguous and has been interpreted by the Michigan Court of Appeals in a couple of landmark decisions and published opinions. So I just wanted to bring to this body's attention that the prosecutor and this law firm is currently in violation of the ordinance of this county that this body approved, as well as the charter provision that governs approval of contracts. Thank you.
Okay, thank you. Anybody else wishes to come forward from the public? Anybody else? Going once? Going twice? We're going to close public participation. Going to move to department recommendations. Sheriff, come on up. Let's get you out of here. It's going to be a long meeting. Yours should be easy.
Appreciate that. Captain Dave Daniels, Macomb County Sheriff's Office. I'm here requesting that the board approve the motion to purchase from New Mobility Solutions, a 2018 Ford wheelchair accessible van in the amount of $53,900. The funding is available for this purchase from the 2019 non-departmental vehicle purchase appropriation in the general fund. The model year 2018 Ford Transit van is equipped with wheelchair lift in the rear and upgraded subfloor and wheelchair tie-downs. This van will be used for our transport vehicle to take incarcerated individuals to and from court and to hospitals and things like that. Like I say, the total cost would be taken care of out of the non-departmental vehicle purchase appropriation in the general fund. This New Mobility Solutions is a sole source provider pursuant to Section 5(1)B of the procurement ordinance. A good faith review of the available sources of vans that are wheelchair accessible. New Mobility Solutions is the only company with used vans available in Michigan. These facts support an exemption from the competitive bid or proposed process based on the fact that the New Mobility Solutions being the sole source of the required equipment that we need. With that,
Okay,
I'll take any questions.
Thank you, Captain. Looks like we have Commissioner Carabelli online. Go ahead. I usually do discussion first, then I do a motion. Go ahead.
Mr. Chairman, is this a replacement, because it says new, so we don't have something like this? This is an addition to the fleet?
We are scheduled to replace 3 transit vans. This is one of the 3 vans we're going to replace. We do not have a current van that is wheelchair accessible. So it's a VIN for VIN replacement for a current number of cars that are
So
in our
we'll be
fleet.
retiring a van?
Yes, sir.
After the, okay,
Yes.
Thank you, Mr. Chairman.
You're welcome. Any other commissioners have any questions for Captain Daniels? Okay, seeing none, I'm going to entertain a motion, if we could. Okay. Moved by Commissioner Sauger, supported by Commissioner Haw. The motion is to recommend to full board the purchase of the New Mobility Solutions 2018 Ford wheelchair accessible van in the amount of $53,900 for the Sheriff's Department. Please vote. Motion passes 13-0 to go to full board. Captain Daniels, thank you very much. Good to see you. Take care.
Appreciate it very much.
Have a good evening. Okay, we're going to move on now to some correspondence that we received. We have a memo here from Corporation Counsel dated May 29th, 2019. That's item 7A. And another memo dated June 5th, 2019. So without objection, I'd like to have Corporation Counsel come up and address items 7A and B. John, come on up.
Thank you, Chair.
Welcome.
The two memos were issued mostly to clarify commission authority and ordinance requirements. They were issued by me not as a threat and certainly not to be challenging. I'm trying to avoid bad situations from happening that will generate additional litigation, which would be useless and senseless. The first concerns the scope of the charter authority granted to this body by Charter Section 6.6.5. 6.6.5 is a special carve-out that applies only to the county-wide elected officials. They are the only ones that are embraced by that charter section, and is the only section that allows county-wide elected officials to directly approach the commission seeking the approval or the actual charter language is authorization of independent counsel. The commission has the authority to do so, but under very, very limited circumstances. It's very clear in that charter section, there are three elements, and that's my term for it, three elements that must be met before the board can legitimately exercise its authority. The first element is the countywide official must be seeking some sort of equitable relief. Equitable relief is either an injunction, a writ of mandamus, or a declaratory judgment. These are lawsuits that don't involve damages for money or anything of that nature. They're essentially lawsuits that require or ask a judge to tell the parties what the rule is that they have to live by. That's the first element, equitable relief only. Second element, that action must be against the county itself. It can't be against any other party. So the first two elements, equitable relief only against the county. And the third one, and this is probably the more subtle of the three, is that the action must be for the purpose, I want to read this verbatim because it is very important, must be for the purpose of clarifying or enforcing the rights, powers, and duties of the office. Now, with all of our countywide elected officials, well, we start the analysis in the state constitution that provides the state, every county must have a certain number of countywide officials: sheriff, treasurer, prosecutor, county clerk. Constitution says their powers and duties are prescribed by statute. The Constitution itself does not give them any authority whatsoever. It says their powers are described, they're provided for in the various statutes of the state of Michigan. I have not looked at the prosecutor. I know at one point I did look for the county clerk, and there are 300 statutes that have the word county clerk in it, in one way or another, providing the clerk some power or duty. So the equitable action must be to preserve or clarify the powers that the statutes give, in this case, the prosecutor. That puts a significant limitation on what the board can do. The current pending request, multiple part request, meets the first two elements. Mr. Smith seeks appointment of counsel for the purpose of suing the county for equitable relief. But in the first instance, to have himself declared, and I'm paraphrasing, have himself declared as his own FOIA coordinator, that power is not in the prosecutor's statutory duties. That is actually reserved by the FOIA statute itself exclusively to the executive in this county. It doesn't say the executive. It says in a county without, or a county not having an executive form of government, is the chairman of the Board of Commissioners. In all other forms of government, it is the chief administrative officer. That would be Mark Hackle. Next section down says Mark Hackle can delegate that duty to anyone he wants. It can be one person, it can be multiple people. There's no limitations in the statute. So a request for appointment of outside counsel or independent counsel to sue the county for some sort of equitable relief to have himself declared FOIA coordinator is not clarifying or protecting the powers and duties of the prosecutor's office. It's actually usurping the powers and duties of someone else's office, the county executive. The next item in that multiple part request, Prosecutor Smith seeks the use of independent counsel for the purpose of essentially becoming his own civil attorney, precluding my office from representing the prosecutor's office in any civil actions. Again, representing the prosecutor's office in civil actions is not within the powers or authorities of a prosecuting attorney. Under our charter, under Section 7, that is actually in power and authority exclusively reserved to my office. Corporation counsel represents the county, its agencies, et cetera, in all civil actions. Again, that is not to clarify or protect or preserve the powers of the prosecutor. It's actually to usurp the authorities exclusively reserved by charter to my office. The last big item seeks injunctive or declaratory relief to preclude my office from ever having the audacity of going to IT to seek records that the county needs to respond to FOIAs if those records originate within the prosecutor's office. Think about that for a moment. In the first instance, the prosecutor's office is a department of the county. It's created by the charter. The charter hereby creates the department of the prosecuting attorney. 2 sections below that, the office of all of the countywide elected officials. Their departments are not separate from the county. They are the county. The county is the departments are the county. There's also just a plethora of case law right on point that departments, operating subcomponents of any level of government do not exist as legal entities. They are the greater entity. They are the county. By analogy, the guys on the line at the Ford plant are not a legal entity. Ford Motors is a legal entity. The guys on the line are part of Ford Motors. It is Ford Motors. So preventing my office, which is another department of the county, from accessing IT records concerning the prosecutor's department reads like this. The county cannot ask the county for the county's records that the county needs to respond to the county's obligations under the FOIA statute. There is less than 0 authority for that position. But more importantly, the limitations imposed by the charter on this commission's authority, that is not a matter within the powers and authorities of the prosecutor's office. It's my opinion that 6.645 simply does not allow this commission to grant the request. If the commission does, I know I've told this to a lot of people, I don't have the horsepower to give you all orders. I give advice, I offer opinions, you're free to disregard them. But the second memo, which talks about our contracting ordinance, is a reminder that the board's exercise of its 6.65 authority, even if it's legitimate, is not the end of the process. 6.6.5 says the commission may authorize the use of independent counsel. That is not a contract. Simply authority to a countywide official to go out and find a lawyer. There still must be a contract before the county is bound to pay. Absent a contract, the county cannot pay. It's not a matter of won't, it's a matter of can't. The ordinance is 2017-03. It was enacted and took effect in November of 17. It's about 19 months old right now. And it is excruciatingly clear and excruciatingly unambiguous that every contract to be valid must be signed by the executive and approved by the commission. Any contract that doesn't follow that simple 2 steps is not valid. In fact, no contract shall bind the county unless it is made in compliance with this ordinance. Several sections later, it reiterates that thought that any contract not approved by the commission shall be null and void. One more section below, anyone who acts in violation of this ordinance has committed a misdemeanor punishable by 90 days in jail. It would be a crime. It would be a crime in this case for finance to write a check, and they cannot do it. I'm saying this because simply approving the appointment is not the end of the process, and you shouldn't consider it the end of the process. You must go to the next step in the process, and that is the law firm must have a valid contract with the county before the county pays. Anything short of that, the county cannot and will not be responsible. Questions?
Okay, I'm sure you're going to have a lot. We're going to start off with
Probably.
Commissioner Kleinfeld.
Thank you, Chair. As Corporation Counsel for the county, when you wrote these memos, did you consider them to be attorney-client privilege memos with the board? Because I noticed that it was only board members you sent it to. You didn't copy anybody else in.
No, they're not confidential. These are not legal opinions. These are just memos. I'm trying to stave off what I can predict is some sort of lawsuit to collect for legal services where there was no county contract. I don't want to engender that kind of litigation. We don't need that problem. We don't need to waste that time and effort.
Okay, because it occurs to me, had they been labeled attorney-client privilege, that would have given us the opportunity to ask you questions in closed session that we can't do now. So I was just curious about
They concern
that.
the charter and an ordinance, both
Okay.
of which are extremely public.
I'm fine with that. I just wanted to make sure. Thank you.
Commissioner Carabelli.
Thank you, Mr. Chair. You covered a lot of stuff.
Yes,
Dial it back just a little bit. Page,
sure.
what page would this be of your memo? Our page 13. Do you have that?
I've got the memos. I'm not sure what your page 13 is.
Well, I'm looking at, I'm sorry, page 2 of your May 29th.
Okay.
Yes, sir. You go down in the indented paragraph, halfway down where it says individual departments. Can you find that for me?
On page 2, I don't think your pages are the same as mine.
Page 2 of 8 of your memo, your page 2 of 8 are,
Yep. Got it. Got it. County.
Okay, it's going to be, it's our page 13. It's our page 13.
the
If you look at,
indented portion.
Yes, the middle talks about statutory construction and the rules of statutory construction applicable to charters also.
Me or him? Oh. All right. John, pull that mic over towards you a little bit, too.
Sure, sorry.
Thank you.
Yeah, what I see in the middle of page 2 is a paragraph regarding the rules of statutory construction and why those are.
If the countywide elected official, that starts there.
Oh. The quote right out of the charter. Got it. Understood.
Okay.
Got it.
As you go down halfway through the sentence that starts out after the bold, it says individual departments. Do you see that?
Yes. Shall
Okay,
not
so I
file
read
suit
this,
against
individual departments shall not file suit against each other. Okay?
Correct.
And any action against the county shall name the county as a party. So it
Correct.
says that we shall not. Then I go to your page 4 of 8, which is our page 15. You go to the second paragraph, the prosecutor intends a bar as required as the corporation counsel is in conflict with the department. The county, however, cannot be in conflict with something which does not exist as a legal entity, and which is instead a component of the county itself.
Correct.
Similar because the department and the county are one and the same. And then you go back to the first part I read where it says we shall not, county departments shall not file lawsuits or sue each other.
Shall not sue each other.
Okay. And yet, your office did do that.
No.
You didn't file a,
Cross claim was against Eric Smith, the human being, the individual, not the department of the prosecuting attorney. We know the rules. We're not going to sue.
no, I'm
sue an
asking, 'cause
entity
I'm
that
reading this
doesn't
and
exist.
it's kind of getting clear as mud to me. And I'm trying to wrap my hands around it because I'm looking at this.
In all of this controversy, far too many people use the prosecutor, the office of the prosecutor interchangeably.
Well, the
And they're-
prosecutor
and
is the
they're
office
vastly
of the
different.
prosecutor, correct?
They're
Right?
vastly different. Eric J. Smith is an individual human being.
I'm sorry, you got to go in the mic. I can't hear
Yeah,
you.
sorry. Eric Smith is an individual human being. The office of the prosecutor is the county department, same as the county.
So your claim was against the
Eric
prosecutor
Smith,
himself
in his name.
and not the department?
Yeah. In his official capacity by
Well,
name.
that's the
County,
department.
though. That would be the county. If it's Eric Smith in his
would be if
official
it-
capacity,
If it-
usually,
If it would be if it was a federal case under Section 1983 of Title 42, but that's only federal law applicable to that class of
Okay,
action.
are you
I'm
telling me?
asking
Are you telling me
that-
it's like a whistleblower case? Are you telling me it's like a case where you have one against the capacity of the clerk, for example, and then the capacity against the former clerk in name? Is that what you're trying to tell me your cross claim was about?
No, the cross-claim was against Eric Smith individually, himself.
But in his individual
I'm
capacity. As-
trying to distinguish between a department and a human being. It was against the human being, not the department.
But I heard,
And the
and
other
I'm not,
part-
this isn't like a court of appeals case and we're arguing here, but you're going to have to clarify. When you brought that cross claim, you said it was against him individually. However, I thought I heard Frank over there say in his capacity, and Frank, come on up if you want, in his capacity as an official. How do you distinguish that?
It was as his position as the elected prosecutor. He's still an individual. There's a distinction between, I didn't sue him on a personal debt. Mr. Smith issued an opinion saying that this board violated the Budgeting Act by budgeting forfeiture money. The declaratory action was to say that this was county money and not public, not state money, as he indicated in his opinion to this board. So
And-
that was it was a declaratory action based on that position, and then if it's county money, all of these things would occur. That's all it was. It wasn't against him for a personal debt. It was because he issued an opinion that this board and our office believed was incorrect to clarify so that you couldn't be charged with violating the Budget Act.
I'm sorry,
That was on behalf
I'm
of the
going back to
county.
wait, hold on a minute.
Yes.
We're going somewhere else that I didn't attend and going, so dial it back for a second. Remember, I'm a little slower, okay? So at the end of the day, I'm talking about the suit that was brought upon by a department, which is the Corporation Council.
No.
Hold on
The
a minute.
county of Macomb.
Well,
The county,
Time
not
out.
a department.
Time out. I'll go back to the first page, our page 13, your page number 2.
Okay.
Individual departments shall not file suit against each other, comma, and any action against the county shall name the county as a party. So I have two parties, both of them are departments of the county.
No.
I'm sorry.
It was the county of Macomb versus Eric J. Smith. Neither were departments. It was the county of Macomb. The county itself was the plaintiff. in
All right, well,
that-
we're
that
not going to answer
cross-claim.
that here. I'm just trying to formulate to understand it, I guess.
It wasn't the office of the Corporation Council. No. Well, I disagree with the layman's interpretation. It was the county of Macomb versus Eric Smith.
Go ahead.
Yeah, that cross-claim or counterclaim was, the cross-claim, sorry, was the county of Macomb versus Eric Smith. It was not the Department of the Corporation Council versus the Department of the prosecuting officer. There are no departments whatsoever involved in that. It was the county, which is a legal entity, obviously, versus an individual.
Then, Mr. Chairman, I got to ask the question, was the original lawsuit against the county or an individual?
The original lawsuit was Maynard, Jared Maynard versus the county of Macomb, and was it Smith?
No, this is the cross-claim?
Yeah. Oh, I'm sorry.
No,
that was-
this
that
is
was
the
Noak-
original
It was
one.
Noak number one. It was Noak number one. It was Noak versus the county of Macomb and Eric Smith. That's what I thought. We've got a whole bunch of these cases going. It's hard to keep them straight.
And it named, and then you're saying that it named County Macomb and Eric Smith individually
Yes.
as prosecutor,
prosecutor.
which is the department?
No.
No. No.
You're making a jump there.
No.
No? Okay. God bless you.
If you
All right.
sue me, it's not the department. If
right.
you s-
All right, go ahead. Go ahead.
Continue with
You-
a couple
you-
quick
of course.
questions. And I brought this up before. When a countywide elected official came to this body and requested an attorney, didn't have the idea of where that fund, the funds were coming from, didn't have a strong case for the board to make a determination if we should allow that countywide elected official authorization for an attorney. And it was denied.
Correct.
Then the request was made again to bring independent counsel in for a countywide elected official because there was a conflict of interest. Am I correct so far?
No. The second request was made by me under my charter authority in Section 7.
I think you're talking about two different things.
Yes.
No, oh, bear with me.
We're talking about Karen Springer. Her first request was made to you under 6.6.5. It was rejected. The second request was made by me under my charter authority under Section 7, where I can come to the board, actually where I may retain outside counsel with the board's approval.
And why did you make that request?
Because,
There was a conflict of interest.
well, that's why we came to get independent
Okay.
outside counsel for her.
And
We
that's
couldn't
where I'm going
represent
to, so
her
you're helping me
and be
along.
suing
So
her.
they asked before, the case wasn't correct, and it was a different issue. Then you came forward and you asked for outside counsel because there was a conflict with your office.
Yes.
The prosecutor's office, you write all these memos, they're asking for basically a conflict because your office, representing as a department, sued his department or an individual, however you want to spin it. And at the end of the day, it came down to basically the same thing. You have a conflict because you brought a suit against him in the department, and now he was asking basically the same thing that you recommended to this body for another countywide elected official. And that's where, if you have a conflict in one case, how come you're not having a conflict in this case? That doesn't add up to me, and that's why you're telling me that you're not going to authorize this to be paid, but yet you've already proven that you've had a conflict. We all know you have a conflict now, so why are you standing tall? And why don't you recommend then, instead of them coming in, why don't you recommend to this body outside counsel for that?
Number one, no one's asked me to. Number two, there's no conflict anymore. That case ended after 4 weeks. That was the case that we dismissed when the Michigan State Police
Okay.
asked.
So
Number
my question
three,
is, because
number
one of the
three.
requests is, I believe, is on the same case, it's actually going to be asked to be appealed. And being that if it is the same case, then to your recollection, if they ask your office for recommendation, that's probably the direction should probably happen, and they should be coming to you, and you should make a recommendation for them to have outside counsel then for, what's it, I don't know what number that is. Yes,
Yeah, Maynard case?
right.
If I was approached and asked, I would reject it for a very simple reason. The appeal is less than frivolous. In the Maynard action, Mr. Smith's attorney failed to file an answer to the complaint. In the Maynard action, plaintiff filed a default against Mr. Smith, and Mr. Smith's attorney failed to take any steps to overturn it. The case was dismissed as moot when the documents, these are the account's checks, were produced. Mr. Smith's attorney then filed an appeal in a default status. A simple reading of the court rule says, once you're in default, you may not participate in the case any further. They cannot attempt to
Who
overturn
cannot,
the party in default.
so there's not a case filed right now in the appeals?
Hang on. I'm just explaining why the appeal is frivolous. You cannot raise the issue of setting aside the default at the appellate court because it was not raised at the trial court below. That appeal is going absolutely nowhere. It would be a total waste of county money. The first issue to be briefed by the appellants, the respondents, is the lack of any ability to even further the appeal because they're in default.
Okay.
So no, I wouldn't waste county money and taxpayer money on something stupid like that.
All right, well, I'm going to have to think about that a little bit because that was a lot for me to take in right now. So the last question I do have for you, you brought an excerpt, cherry-picked a part of a Freedom of Information Act. You said MCL 15.231 on your page 4 of 8. And I read earlier in that same thing, so I guess maybe we should get that entire law brought out so we can look at it, because the way I read it, and it was, again, a lot of big words that I probably don't understand, but it basically said the county, commission, boards, and so forth are the FOIA coordinators for the township, counties, township, cities, and I don't know if villages are within or not. And then this expert you're showing, I didn't see that when I was reading. And again, there was a lot of reading going on, but I do know that it did say that. So I'm going to have to go back because I didn't see where it said county executive, and I just Googled it on my phone, and I didn't see that in there either. So I'm going to have to go back because I don't know. Can you tell me where you found that, where it says county executive?
MCL.
I just pulled that up.
15.236.
And I just looked it up on my
Sub
phone.
3.
And it doesn't show that.
I said it doesn't say Mark Hackle.
No, it says executive, you said.
It says in sub 1, in a county not having an executive form of government, the chairperson of the County Board of Commissioners is designated the FOIA coordinator for that county. Okay, doesn't apply to us because we do have an executive form of government. Next paragraph down, sub 2. For all other public bodies, the chief administrative officer of the respective public body is designated as the public body's FOIA coordinator. If we look at Hackle versus Board, the Court of Appeals opinion that Mr. Davis mentioned, it's the contracting case from 2012. Court of Appeals recognized that the county executive is the chief administrative officer of this county. I don't think the statute can be applied any more clearly than that.
All right, well, again, I didn't see in there where it said the FOIA coordinator is the county executive. Is that something you just put in there, or is that something that is written there? Because you just read it and it didn't say that. It said if there isn't one. So I'm asking, is this the actual?
This is verbatim the statute.
Again, it says the FOIA coordinator is the county executive.
No, I didn't say it says the county
I'm sorry.
I said.
You go to your
For
page
all-
4 of 8, and you go down to.
I'm on 5 of 8, where I quote the statute.
I'm going on
verbatim.
4 of 8.
Okay.
4 of 8. You see MCL 15.231 ET-SEQ directly addresses who may act as the county FOIA coordinator. The legislative there determines that the county, which has an executive form of government, the FOIA coordinator is the county executive. I didn't see that in that law, and I'm asking you where that is, because I didn't see it in 15.231.
One more time. In a county not having an executive form of government, the chairperson of the Board of Commissioners is the designated FOIA coordinator. For all other public bodies.
Okay, so you don't need to go any
including those
further.
with an
So you
executive
threw
form
in
of
that the
government.
county coordinator is the county executive on your own, and it's not in the actual law. I'm just trying to understand this.
It is. It is.
Okay, I'm done.
We're playing word games, but it is.
Yeah, all right. I'm just gonna interject, just because I have a question
Yes.
before we get to the next. Going along the lines of what Commissioner Carabelli was indicating, you referenced the 2012 or 14 case, Hackle versus the County Commission.
2012, yes.
And you feel based on that case, which is a contracting case, because the Court of Appeals, would you agree, was in dicta, recognized that the county executive is the chief administrator? You could argue that that's in dicta, that is not definitive. Would you agree with me on that, Mr. Shapka?
I'm not sure I'd agree that.
All right, you don't want to. Okay, that's fair enough. All right, the second question I have, and I'm going to let everybody else talk, is this. If you analyze the FOIA law,
Yes.
there's not a lot of case. It's unclear. It's not exactly clear law. Some counties have department heads, for example, the clerk, the treasurer,
Yes.
that actually have their own prosecutor's office, that have their own administrators. No question about that. I'm going to ask you this, and I know I asked you this before, and you're going to have to answer this. There is nothing in writing. We don't have any kind of ordinance. We don't have any kind of executive order wherein the county executive has said to you that you, Corporation Counsel, are in fact the FOIA administrator. We have nothing like that in writing. Is that correct?
The statute doesn't require it in writing. It's not in writing, but I've been told many times.
Okay. The statute may not require it in writing, but our county, a pretty large county, doesn't have anything in writing at this time. It's just simply what you were told.
Nothing in writing since the executive form of government.
Okay.
Prior to that, I'm told, I wasn't here at the time, I'm told that the board in writing declared the corporation council to be the FOIA coordinator.
Well, that would be for the
That
board.
that
Right.
predates the charter
Right.
form of government.
But the board is a separate, and you would agree that you're under the county executive, right? Corporation councils, if we look at that plan that we just approved, your corporation council falls in with the county executive, isn't that correct?
I actually haven't looked at it.
Okay.
I know what the executive's plan
Right.
shows.
And the executive is a separate form, I mean, this executive is a separate governmental unit. County commission.
No, it's a branch.
It's a branch, that's what I mean, it's a branch.
The executive's office is a
County commission
department.
is a branch.
Yes.
And then we have our different departments that are outlined in section 7. Clerk, treasurer, prosecutor. Now, there's no doubt, if the county executive said to you personally, you, underneath my department, my branch, you are going to be my FOIA executive, that would count for the county executive, for roads, for IT, anybody that falls underneath that department. Isn't that correct?
No, that would count for the county itself.
You believe that if that's based on your opinion from the Hackle case?
No, that's based on the statute's clear language.
Well, again, I think that, let me just say this, and this may not be the appropriate forum, but the bottom line is there's a little bit of unsettled law on the FOIA thing, and I'm a little bit concerned to some extent. That we don't have anything in writing indicating, I mean, if somebody FOIA'd the county right now, I'm pretty sure almost every department head is going to go to you. No question about that.
They do.
But the statute indicates that the department, you can't argue that the statute indicates that department heads, prosecutor, treasurer, clerk, could have their own individual administrators. The statute clearly says that.
No,
You
it
can't
doesn't.
deny that.
It does not.
I
Clearly does
disagree.
not.
Okay, well, all right. Anyway, I
Absolutely
won't take up
clearly
any
does
more
not.
time. That might be something we'll have to take a look at later, but for now, I'm going to give Commissioner Hall the floor.
Thank you, Mr. Chairman, and it's tough following two lawyers arguing differing opinions, so thank you for that, too. In your mind, John,
Yes.
in your mind, based on what Commissioner Carabelli has said and Rob's differing opinion than yours, in your mind, through the power of the charter under 15236.1.2.3, are you the designated FOIA coordinator for the county?
I am, because the executive has delegated that authority down. The executive can make multiple delegations. In this case, he's only done it to one office, mine.
Okay. Second question, and I'm going to go back to what you moved over pretty quickly and indicated it's not the end.
Yes.
Under your June 5th memo, last page, you had indicated, or I'm assuming you, right?
Yes.
Since we're going to play with semantics here, I'm going to play a lot.
Well, I wrote it, so yes, this is me.
Thanks. I know we pay attorneys by the word.
I
Lastly,
fixed overhead.
Ordinance 6.1 makes clear and beyond debate that any contract that is not submitted to the commission as provided in this ordinance, and any contract that requires commission approval under this ordinance but is not approved by the commission as provided in this ordinance shall be null and void.
Yes.
So in your opinion, under the approval process,
Yes.
that I'm assuming everybody in this room has agreed to, you are not approving this request.
I don't have, in the contract action, I don't have any approval authority whatsoever.
Okay.
That is the commission's exclusive approval
You-
authority.
Thank you. You move on to a null and void contract shall not be binding under the county ordinance. So you have indicated, hypothetically, if we approve this request and it goes through and a bill comes to finance, Schmiegel cannot pay it under threat of violation of a misdemeanor.
On the strength of the commission's action under Charter 6.6.5, authorizing the use of independent counsel alone, nothing
Right.
else.
That's what I'm
With
talking about.
nothing else, with no contract, you're correct.
Okay, Then
The
you
bill
go.
cannot be paid because there is no contract running to the county, making the county responsible for payment.
Okay, and then you go on, and I want everybody to hear this statement clearly. Who pays any amount or takes any action in violation of this ordinance or performs any action pursuant to any contract that was not approved and signed as required by this office may be subject to personnel action.
Yes. Workplace,
Who are you referring to there?
anybody. And personnel, not personal, but personnel
Oh,
action.
personnel, okay.
Is workplace disciplinary action.
Okay,
I didn't include it in the memo because quite frankly, I thought it was awfully heavy-handed and sounded like a threat, but the next sentence says, anybody who violates it is guilty of a misdemeanor punishable by a $500 fine and 90 days in jail.
no, it didn't sound like a threat
Well, I
because
didn't
I've
want it to
talked to
sound like-
two municipal attorneys today who have indicated it and read the ordinance and indicated there could be a whole lot of people subject to personal as well as personnel action. Do you agree with that?
At the
And these
risk of-
guys
at the
represent
risk-
9
at the
different
risk of
communities, so
sounding
be
like
careful.
I am- At the risk of sounding like I'm threatening, I'm sincerely not.
No, I didn't say
That
you
is
were.
a-
I just
that
want to
is
know,
a-
do you agree with the
I would
assumption?
agree there is potential liability.
Okay. Lastly, again, not to the end, we had an individual, and I won't use his name out of courtesy, who talked during public participation, indicating there was a court case going on Monday
Yes.
where Clark Hill was representing the county, or the prosecuting attorney.
Yes.
Were you aware of that?
I believe 2 Fridays ago, Mr. Jensen, my office, received a phone call from that Clark Hill attorney just out of the blue who said he's making an appearance. He actually did appear on the record Monday of this week. That hearing was inconclusive, was put over till next week, and I assume he's going to appear again next week. So yes, that is true.
And who's paying that bill?
Not the county of Macomb.
Not the county of
There is no
Macomb.
contract with that firm or that attorney.
So you may not know the answer to this. Was Clark Hill representing the prosecutor, the county, or both?
In that case,
In that case?
the parties are the county of Macomb and the department of the prosecuting attorney. Those are the named defendants. The department of the prosecuting attorney was dismissed, so now it's just the county. That Clark Hill attorney appeared on behalf of Eric J. Smith, who is not a defendant, not a party.
Sorry, he stated that on the record that he was appearing, or he filed an appearance saying he was representing Eric J. Smith?
Did he file an appearance? Well, that's today's motion. Did he file an appearance? Okay, yes, he did file an appearance. As of today, as of this afternoon, there is a motion from that Clark Hill attorney, a motion to intervene in the case. But 2 weeks passed, there's nothing of that nature.
But he didn't file anything saying he represented Eric J. Smith. He just filed,
Maybe he stood there and looked at the judge and said that's who he's representing.
but did he file paperwork to that extent?
Well, we're getting into legalese talk again.
I know.
here.
I don't mean to do that, but it's important.
I'm sorry, his
Yeah.
appearance was not for Smith, it was for the department.
Okay.
Which had already been dismissed.
Okay. All right. That's what I wanted to know. Thank you.
Which is also the county.
Okay. No, fair enough. Thank you.
Okay, that,
Thank you.
I was going to say that may have clarified something for you, but it confused it for me. So,
Basically, we're representing the county, somebody showed up and said, I'm representing the county too. Well, the part you think you're representing is already dismissed. Today's motion is to intervene on behalf of named individual Eric J. Smith.
okay, and I probably don't need to say this, but I'm going to. There is nothing personal, not personnel, personal, about any of the questions I'm asking or the direction that we may or not be heading. But you have indicated if we approve this and it goes through and somebody, I believe the motion was to change it to Clark Hill, who represented or didn't represent, I don't even know where we're at with that, on Monday, already there, you get a bill from them, you're not paying it.
As long as there's no valid contract under the contracting ordinance, that is correct.
And they're already acting on that behalf.
Apparently so, yes.
And the individual that spoke, who I will still remain nameless, indicated there was some misdemeanor or whatever that was about. I didn't quite understand how that is not under our charter.
I heard the same words that you heard. I would disagree that anybody's committed a misdemeanor so far because there's no payment made in the absence of a contract.
But if there was, you would have to defend that as well?
Misdemeanor is a crime. My office does not do criminal defense. By charter, we don't. We're just the civil attorneys for the county.
Okay.
And quite frankly, I wouldn't hire us to do criminal defense because none of us do that, and we would not be very good at it.
Okay. I also, my last thing, Mr. Chair, thank you
Take
for
your
your
time.
tolerance. I pulled out a lawsuit. I was looking for a date on this thing, and I didn't really find it. It is Macomb County Board of Commissioners versus Mark Hackle in his capacity as Macomb County Executive. And in
the case number on that, the first two digits at least would give you the year of the filing.
2018.
Okay, so
it's recent.
So it's 18.
And in this case, it says the county executive has violated, we're saying this, I'm assuming, the county executive has, I don't want to assume, I'm reading it out of the court document.
Understood.
So it's the Board of Commissioners that are suing the county executive making this statement. Is that, am I on the right track here?
You're good.
Thanks. I could ask you, Rob. The county executive has also violated ordinance 2017-03 by not obtaining the commission's approval before entering into intergovernmental contracts and/or grants. So the Board of Commissioners is suing the executive for doing what we're pretty close to discussing in items 9A, B, and C. Is that a good assumption?
No, you've jumped one step too far. The lawsuit accuses or asserts or alleges the executive violated the contracting ordinance.
Mm-hmm.
What you're being asked to do in 9A, B, and C, D, whatever, is the step before the contract or a contract. You're simply, and you got to look at that charter language real carefully, you are authorizing the use, authorizing the countywide official to go get a lawyer. That's all you're doing.
Mm-hmm.
You're not contracting with that lawyer. You're not doing a contract. The board can't originate contracts. They have to come up through the
No, I
executive's
thought
office.
there was wording in there with a retainer amount and an hourly amount in one of these 400 documents we have here. So
When I come to you and ask for permission to hire outside counsel, that's standard information that you need to know. What's it going to cost the county? Who is this person? Do they know what they're doing? You're not going to squander county money, taxpayer money, on somebody who is inexperienced and is charging $1,000 an hour. So I'm not surprised that language is there, but you're still under the charter authority of 665. At the most, all you're doing is authorizing the use. You are not actually cutting the contract. You are not forming the contract. You are not writing the contract. You're not approving the contract. The contract has to come up through the executive with his signature for your approval like every other contract. And the case that you have there is the board's contention that the executive formed contracts but didn't get the board's approval, which would be a violation of the ordinance.
I think I'm done, Chairman. Thank you.
Good questions. Okay, thanks, Harold. Commissioner Gillette.
Thank you, Mr. Chair. John, thank you for your presentation and your memos. I just want to go over something you said about the case involving one of the cases that we are being asked to appoint an attorney for. There was a suit by Maynard, or rather there was a FOIA request by Maynard.
Yes.
That FOIA request ended up in court. The court ruled on behalf of Maynard. Then the court issued an order of some sort to require compliance by.
It gets a little complex. The court gave the prosecutor 2 weeks to appeal the court's ruling that the documents were public documents.
Okay.
The prosecutor pursued that appeal on an expedited basis.
Okay.
Court of Appeals rejected it on an expedited basis.
Okay.
Talk into the microphone so we have it.
I'm sorry. The court rejected the expedited appeal.
Okay.
At that point, the matter falls back in the trial court's hands. Trial court's order stood. The checks, these are the forfeiture account checks that are at issue here, were in fact public documents. They were in fact produced, and they have been in fact provided to Maynard, and since then the board, Michigan State Police, and everybody else who's ever asked for them. The issues in the Maynard appeal are absolutely moot, and the appeal really can't go forward because of that default situation.
Well, what's the default part?
The prosecutor's attorney failed to file an answer to Maynard's complaint. This is the first week of civil procedure. There's a complaint, you have to file an answer. If
Okay.
you don't, you're in default.
So if you're
you
in
go into
default,
default, you cannot participate in the case any further.
okay. So since the prosecutor is not its own legal entity,
Correct. Well,
the default is actually on the
office-
counties.
The office isn't.
Right, the office is not. So in other words, the county defaulted because the prosecutor did not, or
No, the county answered the complaint.
then we're not, there's no default.
No, there's a default against the prosecutor.
The prosecutor is not a legal party,
Mr. Maynard is represented by Frank Guzmano.
right? I don't get it.
Well, that makes things less than clear.
I guess I'm saying that if there was a default in the case, and the case cannot proceed any further, essentially the county is the entity that Maynard is essentially having to sue, right? Because the prosecutor is not a legal entity, right?
Peter represented us in this case.
The prosecutor was individually named in the Maynard case. So the defendants were the county of Macomb and Eric Smith as prosecuting attorney. So he was individually sued.
As an individual?
Yes, and in that case, the county filed an answer, pretty much saying, yes, you should have the documents. And we were informed by the prosecutor's office that we were not to appear on their behalf, for whatever reason. What finally happened was Judge Cervetti said, look, Servito, I'm sorry, it says, county, write me a legal opinion. You're the county coordinator. I wrote a 5-page legal opinion saying the checks are public documents. The court agreed with me. We issued a subpoena then to the bank saying, okay, give us the documents. The court then gave the prosecutor, for whatever reason, 14 days to get the Court of Appeals to say that they shouldn't release the records. The Court of Appeals denied that appeal, and the next day, we, through the subpoena to Chemical Bank, got all of the records from 2012 to 2017, and at that time, we had all the records and disseminated all the records. Mm-hmm. That's where the suit lies now. The appellate issue is what? You can't give out the documents, they're gone. They're not public records. One, the exemptions under Section 13 aren't mandatory. That is, even if there was a provision that say you can't release it, there's nothing that would prevent the release of those documents.
So do we know what the basis of the appeal is now that the records are already released?
Don't have a clue.
Okay. Okay, I would put this forward then. At least in my case, having read the memos that were provided to us by your office, and in having just poked around the state law myself, in my personal case, I believe that based on what I've read, you are correct that the county executive is the FOIA administrator for Macomb County. However, in the case of the Maynard appeal, couldn't somebody make the argument that it makes sense that if there is going to be appeal on that it should be an independent attorney, and that therefore you should come to us and request one because of the clear conflicts of interest involving this specific case?
Two things. He never raised that. Prosecutor, one, we don't know what the prosecutor is going to say because he didn't say anything. So the Court of Appeals does not, the Court of Appeals does not have in front of it a record stating that they think the prosecutor has a conflict, so there's nothing in the documents on that. There's nothing in the records to suggest that the prosecutor believes that the prosecutor is the FOIA coordinator. The court never addressed any of those issues because the prosecutor never raised them. And at the risk of sounding too much like an appellate lawyer, the bottom line is the Court of Appeals will not resolve issues that were not raised below. So there's no record for them to look at to say, oh yeah, the prosecutor should be the FOIA coordinator. That's never going to come up in this case because it was never raised.
No, I'm not suggesting the prosecutor should be the FOIA coordinator. Or an issue in this case. It's just in that specific case in which the county has been in conflict with the prosecutor.
What's the conflict?
The conflict is we filed a counter against them, a counter claim against them. That's a conflict, is it not? I mean, he's asserting one thing, and then the county files a counterclaim.
I don't know what he's asserting because he never asserted the assertion he made. Well, Judge Savita requested an opinion as FOIA coordinator from our office. We gave him the opinion. The judge agreed my opinion was correct, and that led to the subpoenas being issued.
Okay.
So I don't know where the conflict is.
That's all, I'm sure well-documented legal stuff. But doesn't it seem obvious that the county's in conflict with the prosecutor on this case?
Well,
we filed a counterclaim. Forget what the judges and the files and the forms.
One, I don't think in this case. And secondly, are we suggesting that every time a county official doesn't like the answer of Corporation Counsel, we should give them an attorney to debate it in the courts? I'm not saying that, John. I
think it's important to remember the counterclaim was in another case, not this one.
It was not in the Maynard case?
It was not in the Maynard case. It was in Noke number 1.
Oh.
More importantly, as Peter said, any issue that's not brought up at the trial court cannot never be brought up at the Court of Appeals. Paying taxpayer money for an attorney. I've been trying to get smaller for years. Paying taxpayer money for an attorney who will not be able to speak because his client is in default is a waste of taxpayer money. Paying money to further an appeal, which is at best very amorphous, we have no idea what the issue could possibly be, is a waste of money. Paying money to appeal an issue which is absolutely moot because the documents have in fact been released, and once released you can't get them back. That is a waste of taxpayer money. But more importantly, the Maynard case does not explore or protect any authority inuring to the prosecutor by any statute. The commission's hands are tied under 665. You can make the first two elements. Well, actually, you can't make any elements in Maynard. It's not a case against the county seeking declaratory relief for a power that inures to the prosecutor by virtue of office.
So,
and the same with the second one, Trendle. Trendle's even worse. Mr. Trendle is pro per. He has no lawyer. So his complaint was gibberish. It was dismissed on an instant motion.
Would it be fair to say that in the case of the clerk then, in the cases where we provided independent counsel, there was a contract that was approved by this board, signed by the county executive for those attorneys in every case?
I believe so.
Okay, and would it be, and that's been the case as far as you're aware, anytime that a independent counsel has represented any countywide or a department head?
For the very few times that we've done that, yes. There's some sort of retainer agreement, which is the contract.
Gotcha. Okay, thank you very much. Thank you, Mr. Chair.
You're welcome. And just, I'm going to make a note before we get on to the next, because we're gonna have a chance. You're going to hear from the prosecutor. I mean, when he comes up and talks about his 9A, B, and C, just keep in mind some questions you might be able to ask directly to the prosecutor's office during their point in this. We're going to go into closed session before we do that, but just so you know. But go ahead, Commissioner Kleinfeld.
Okay, one of the reasons for my questions now is we are going into closed session for attorney-client privilege on a memorandum that we do not yet have, correct?
Yeah, that's correct. We're going to be going.
So-
We're going to, but our attorney is here. Our attorney is here, and
Okay,
we're going to.
well, yes is the answer. So what happens then is we get the benefit of his response to corp counsel, but because we're going into closed session for that attorney-client privilege, we don't get the benefit of his response to our counsel or the benefit of the prosecutor's response.
First of all, this is not a courtroom. Okay.
I have the floor.
I'm going to wait, but I'm going to tell you this. This is not a courtroom.
You've been sitting here citing.
Hold on. We're not going to get into a fight. I'm just saying this.
I'm not holding
you can
a
ask
court.
any questions you want to Corporation Counsel,
And I'd
we're
like
going
to
to ask any
explain
questions we
myself.
want to our counsel, and we're going to ask any questions we want to the prosecutor. We don't have to have rebuttal. This isn't a courtroom. But go ahead.
No, he gets to rebut him. He doesn't get to rebut him. That is my point. So I'm going to continue on with what I was saying. Personally, if we're going to air this out in public and we're going to air the prosecutor's position out in public, then we should air our own attorney's position out in public so that we could hear the counters and really hear what everybody's saying. We're not doing that, which is one of the reasons I had asked if this was attorney-client privilege document, because there's a benefit taking place one way that's not taking place the other. Okay, now, your position is that the executive is the FOIA coordinator and may delegate that.
Correct. Clear in statute.
Okay. Commissioner Leonetti asked you if there was anything in writing, any policy or anything with that nature. Is it your position that the executive can change that delegation or state it at any time?
At will. He can change it at will. It's a discretionary matter with him.
Now, the county, I had a question about, wouldn't the prosecutor have had reason to believe that the county would answer on his behalf, as we have in other cases where we've removed the sheriff from a case because he's not a county entity, and you just stated you were told not to appear on his behalf. Is this before the whole cross-claim thing, or is this a different case?
Before the cross-claim, this is a separate case.
But it is before the cross-claim.
And in every case handled by my office, we make contact with the official and ask,
Okay,
do you want us to
so
represent you?
before the cross-claim, you were told not to handle anything on his behalf.
Correct.
Okay.
Well, not anything, not that FOIA lawsuit.
Okay, thank you. And you said this is not this one on appeal is not the Maynard case. Is it a Maynard case?
The one on appeal is the Maynard case.
Is the Maynard case.
The case with
It's
the cross-claim was NOC, N-O-W-C.
Okay, yes, yeah,
Nope.
but he had said it wasn't, so I just wanted to clarify, it is. Okay, so, so with respect to the appeal itself, does the prosecutor, if he's not the county entity, well, is he suing on behalf of his department? Does he have the right to appeal?
As a person, anyone who
As
has a
an
right
individual, does he have a right in his capacity?
to appeal?
Yeah.
Yes, anybody can file an appeal if
I
they're
mean,
party
in
to
his
the case.
official capacity. That's why I'm asking. Usually, departments aren't allowed to, and that's why I'm not sure about his authority to do an appeal.
Well, I was confused about his authority to represent himself or have one of his office mates represent him in a civil action, or that is the exclusive province of my office.
And you
This is
indicated
very
that he
unusual on
didn't
many
respond to the original filing
Didn't file an answer to the
on
complaint
time, within a week.
at all.
Yet we did an emergency action where I supported a bypass that the rest of council didn't get to vote on to get him an attorney. That was after the fact. That was after the cross complaint.
I believe that was,
Okay.
yes.
So you didn't respond because you were told not to, and then he didn't respond.
Correct.
Okay.
We responded for the county.
Okay,
Now for
and
the
then
prosecutor.
my last thing is, and I think I understand what Commissioner Carabelli was trying to say because the law is a public body in a city, village, township, county, or state department under the control of a city, village, township, county, or state department shall designate an individual as the public body's FOIA coordinator. Okay. The FOIA coordinator shall be responsible. So at this point, before you get to the county not having a county executive, so at this point, the public body, I think we're making the position that the public body is this board. So at that point in the law, and it says the FOIA coordinator shall be responsible for accepting and processing requests. And then it says, in a county not having an executive form of government, the chairperson of the County Board of Commissioners is designated. But what it doesn't say is affirmatively, if the county does have an executive form of government, the County Board of Commissioners chair is not the FOIA coordinator. It's written in an odd way. Would you agree?
It is written in an odd way, which only
And so when you
legislators can
look
do.
at this when you look at the first part of that, before that sentence, and you determine, okay, we're the public body, therefore we're the FOIA coordinator. And then you see that sentence that is an affirmative in nature. It doesn't necessarily say we're not the FOIA coordinator, and I believe that's what Commissioner Carabelli, and now I know where our attorney's going to go, which isn't an opinion that I've yet seen. So I just wanted to clarify what the questions were being said on this end, because the light bulb went off and I understood what they were saying.
Yeah.
That's it. Thank you.
Again, I've got to disagree with that interpretation.
And I'm not saying,
I think
I'm not
the
affirming or
statute- yeah.
denying. I'm just saying that's what's being said.
Yeah, the
Hey,
statute's very
Commissioner
clear.
Kleinfeld, that's exactly where I was going with it. The statute is a little muddled. It's a little muddled. So we'll get into that, I'm sure, in closed session. But and that's what Carabelli was at. That's where I was at, and that's where we have a little disagreement on. But it is, and he just said it. It's a little muddled. He may have some disagreement, but it's a little muddled. Anyway, Commissioner Smith.
Thank you. Thanks. John, I have a clarification. Commissioner Hall mentioned, or maybe it was Commissioner Drollet, that our case, the Board of Commissioners against Mark Hackle in his capacity as executive, sounded the same to me as the case against your case against Eric Smith in his capacity as prosecutor. But it sounds like you're saying that as in the case against the prosecutor, it was in his individual capacity. However, in the case that we have, the counter claim that we have in the case that's going on right now, that it's Mark Hackle as his executive, so we're suing the executive's office. Is there, and maybe I'm just confused because I'm an attorney that doesn't understand a lot of that stuff yet.
Suing an official by name in the capacity of their office, you're suing the official. That's why his name is there.
So
in any case, you're suing Mark Hackle.
Okay, and that's what I didn't get, because it made it sound like it was something
You couldn't
different
sue
in both
Mark
cases.
Hackle, private citizen, because he would not have any authority to act under any of the ordinances or charter provisions. You have to sue him as the executive, which brings into effect the charter and the ordinance sections.
Okay, so
The
it does
ordinance
bring
doesn't
in, it
apply
does
to
bring in
civilians.
his official capacity as executive, so it's the executive.
In his capacity as executive.
Okay.
Civilians, non-county employees, have no obligation to follow this ordinance or the charter.
Right.
That's why you have to sue somebody in their office, which brings all to bear all of this body of law.
And I just wanted to understand that, because I'm not, I haven't practiced very much like that, so I just wanted to understand. So my next question, and I've recused myself from the actual voting on this item. However, my curiosity and concern on this item is a legislative duty versus, is it or isn't it, right? I mean, so this whole thing with the FOIAs and the whether we have the right to do this or not, this could come up in any situation. So, however it happens to be my brother, my concern is whether we have a legislative duty and authority to do something, or we don't have that right to do something. So I'll just tell you where I sit on this thing and where I'm going with this. You mentioned something earlier on about contracting without proper authority and misdemeanors and executing on contracts. And I guess my question to you is this, that over the last year or more, we've had this exact situation with contracts coming before the board that had been executed, not approved by the board, executed, paid, and I'm just wondering if you have the same advice for everybody in the county, because we are aware that that's happened several times.
I would give the exact same advice regardless of who it was or what position they occupied. So the ordinance is clear, it applies to everyone evenly.
Okay, I understand that. Last week we had a case, where the roads were getting done, where the question, we didn't have a request until after they were getting done. So this is something that's going on. My point to you is you're the corporation counsel for the county, and you're here to protect the county. You're saying that there could be a problem with obviously paying things that weren't, properly contracted for, and that goes both ways. And I'm just recommending that message get all around the county.
I'd be real happy to send this memo to everybody.
Thank you.
Yes.
I'm just helping. It says Mark Hackle in his capacity as Macomb County Executive. Yeah, that's what I thought. So you were right.
Okay. Commissioner Brown.
Thank you. Thank you, Mr. Chapman, for this grilling. The question about who this board gives an attorney to represent them, you set it off, gave 3 specific categories. They're pretty narrow.
Yes, they are.
And Karen Spranger, Karen Spranger is the most recent example that the board has of where we gave an attorney we didn't do a value judgment on her use of that attorney. You gave us a litany of reasons why, in your opinion, it was your opinion, why we shouldn't expend money on an attorney to represent them in 3 separate cases, because in your opinion, they were, the outcome wouldn't be something that would be favorable, or it would be a waste of money or something like that. But it spoke to your personal opinion about the case, questioning whether that elected official questioned their judgment as to what they're going to do with the attorney once we give it to them. Should that even be our concern? If the elected official wants an attorney to help them defend themselves and their office and their capacities of their office, should we have even any say-so in that at all? Because it's their decision, it's their office. Do we have to make a value judgment on what they're going to do with it?
There's actually two issues that you've raised.
Yeah.
One is the extent of your authority to authorize counsel.
Yes.
The second is your discretion. You're not compelled to authorize just because somebody makes a request.
Yeah,
So
I
the
understand
first
that.
line of analysis is, does the charter provide you the authority in a given situation? And the second inquiry is, even with the authority, do we want to spend money that way?
So
That is your discretion.
That's right. We have the authority to do it if we want to, period, right?
Correct.
Exactly.
Well, assuming that the charter authority exists in a given situation.
Okay. Thank you very much. Thank you.
Thank you, Commissioner Brown. John, I have a question, thinking forward here a little bit, and it goes with some of the comments that were made here. I get it, that you were not initially told by the prosecutor, look, we think there's a conflict. That wasn't raised in the Maynard case. It wasn't raised in the Knock case. However, looking forward here, we've got 3 other cases that have recently been filed. They weren't added to this agenda because we didn't think it was timely enough. It'll be added on next month. If at some point, and this goes for any one of the 3, you guys back there too, okay? If at any point the prosecutor comes forward and says, look, officially on these cases, I feel there's a conflict, what would be your thoughts then?
6.6.5 makes absolutely no provision for conflict. There's no exception to the limitations on the commission's authority. If there's a conflict, if it ain't fair, if we're feeling magnanimous on a certain day. That charter section is excruciatingly clear and very narrowly drawn.
No, and I get that. I get that. You're talking about a deck action. You're talking about, I get that, equities.
To protect the
right.
powers
I'm just
inherent to
talking
the
about it.
individual body
I guess I'm just talking about from Corporation Counsel's standpoint. Given that you filed a cross claim in one case, this is attorney to attorney sort of. You know, you filed a cross claim in one case. He's indicated, I don't want you doing anything for me and anything else. Now we got these new cases. If it was raised by his office, whether he gets an attorney from us or whether he does it with one of his staff, that there's a conflict, what would be your thoughts in that regard? Would you come to us, I guess, like you did with Karen Springer and say, hey, we feel a little uncomfortable with this. We're witnesses. You guys need to get independent counsel on this.
Maybe, but no one's asked.
Okay.
Having said that, I would do exactly what the commissioner would do, assuming he has 665 authority, and I would weigh the equities of, is this a meritorious pursuit? Is it a case that
Right.
the county
So you're
should
saying,
spend money
you're saying in a sense, let's take a look at it in a case by case, somewhat. I got you.
Under my charter authority, it says the Corporation Council may retain
That's
outside
right.
counsel with charter or with
Right.
commission authority. So again, that gives me the discretion.
It gives you discretion, exactly.
Correct.
And so I just wanted to know, we've got 3 other cases that are coming here. This is a problem that's not going to go away anytime soon. So, and we've indicated in the past that we're going to look at it on a case-by-case analysis. So we want to know a little bit about what your thoughts are on some of these things as well. Okay. Commissioner Drolet on the second round.
Thank you, Mr.
Joe, you know what? You're absolutely right. Will you yield the floor? Okay. Commissioner Romano? The floor. Go ahead. I'm originally from East.
You know, thank you, Mr. Chair. I'm listening to all this conversation, and I'm listening to Mr. Shabka, our Corporation Counsel, trying to explain these. I personally, I kind of agree with Commissioner Kleinfeld. I'm hearing Mr. Shabka's viewpoint on it, his interpretation, so to speak, even though he says it's very clear in the statutes. I'd like to hear from the prosecutor's office. And I think she makes a point by saying, once we go into closed session and we hear from our attorney here that we've hired, how can John respond to that if that's in closed session? How can the prosecutor's office respond to that if it's in closed session and it's not supposed to be discussed? So, having said that, I think we've grilled poor Mr. Shabka enough. Let's get the other side of the story and let's hear it. Enough of the conversation.
Let me address this. We can do this one of 2 ways. We're going into closed session because we're talking to our own attorney. That's the best thing to do when you talk to your own attorney. However, I will say this. If you want, and this would require a motion, we don't have to go into closed session first. We can hear what the prosecutor has to say, but we're not going to vote on what he has to say, I think, until you want to go into closed session. So the way we organized this agenda was, let's hear what our Corporation Counsel has to say. They've said what they've had to say. Let's hear what our attorney has to say about what not only he says, but what the prosecutor is saying in what he's put in his, requests. And then, now that we're informed from Corporation Counsel, we'll have some enlightenment from our counsel. Let's hear what the prosecutor has to say, and let's vote on it. I just think that makes some logical sense on it. I don't think this is a debate or a courtroom. I just think we want to get as much information as we can from key players, Corporation Counsel, our counsel, and finally the prosecutor's office. I just think that's a logical way of doing it, and that's why we have it that way. Certainly, if you guys want, now that we've had Corporation Counsel, who seems to be at odds with the prosecutor's office, we can have them come up, but then I'm not so sure we want to vote on what they have to say until we hear from our attorney. That's just my point on that.
Thank you, Chair, and I totally agree with you, but I think out of just common courtesy, I think we should hear the prosecutor's office. Then let's talk to our attorney in closed session if we decide, because he's going to hear what the prosecutor has to say, and maybe he could, if he wants to discuss that while we're in closed session, he has something to say. Otherwise, we're going to be talking to him. Prosecutor's going to come up, bring up some stuff. We're going to say, wait a minute, that doesn't make sense because we talked to it doesn't. That's my personal opinion.
If you folks want to move the prosecutor's office right up after Corporation Counsel, we can do a motion to amend the agenda. The only concern I have is I wouldn't vote on it until after we go into closed session. Well, I'm only the chair here.
I'll make a motion that we hear from the prosecutor's office.
Okay, there's plenty of support. We got it from Romano, and we got it from Lucido. Sure, go ahead. There's a motion.
Thank you. We're under correspondence, so do we even need a motion to have them come up and speak?
Well, that's a good point. It is correspondence.
It's correspondence.
Can we have anybody come up and talk during correspondence? Okay, then that's fine.
That was my thought.
Right, because we don't even have them on the agenda separately, so there's nothing to
We do have them separately. They're after closed session.
Oh, the request is.
Yeah, their request is. Okay, I have no objections if we're done grilling poor Mr. Shea.
I didn't want to give the floor forever.
Sure.
It's just,
Yes, you do.
I just had one question left, and it'll be as quickly as possible. When our board did the override and hired the attorney to represent Eric previously, was there a contract then that was signed to hire that attorney? At that point, was there a contract?
Not that I've ever seen, not that I'm aware of.
So did the finance department pay that?
Nope,
So that attorney has not been paid?
not yet.
Okay.
I believe the invoice arrived yesterday or the day before.
Do you know if there is an intent to pay it?
There's not going to be an intent to pay it absent a contract.
Thank you.
Okay, well, hold on. Yeah, go ahead. Point of order, go ahead.
Just for clarification, though, I did contact John, not with regard to a contract, but whether or not in that specific incident we needed to give him his own attorney, and you agreed with me that that was the right thing to do in that particular situation.
The counterclaim,
Yes,
not Maynard, I'm sorry, cross-claim.
correct. Just
No.
the counterclaim. The cross-claim.
No,
What-
counter.
It was, you guys filed a cross-claim against them, and we approved
We're
to
both
give him.
defendants, that's a
Well,
counterclaim.
yeah, okay,
Cross
I
is
guess we can
against
play the semantics.
Cross is against the
I
plaintiff.
just wanted to make sure everybody knew that I did check with you, and that was in that very narrow incident. So the lack of the contract would be our fault. No, no. So we do have an issue there. Thank you.
Okay.
Well, let's just clarify something. Hold on. We approved and authorized, as he says, we authorized the county prosecutor because he was sued in a counterclaim, cross-claim. We authorized so that he could get counsel to help him in that action. You've just heard Corporation Counsel say that was the appropriate thing to do. We did not, this may come up later, we did not do the contract. We just authorized the county to go ahead and that particular department to get himself an attorney on that issue and that issue alone. And that was the appropriate thing to do.
Correct. Correct.
Joe, you're still on the list. You want to say anything else?
Yeah, I'd like to hear from the prosecutor's office.
All right. John, thank you. Josh, I assume you're going to come up. Are you ready for the grilling? I see you got some other members here that might pitch in, so good luck.
Well, first off, there is a contract for the first case. It was provided to the board, and the retainer agreement with the attorney was provided. And I believe the board even moved or made a change to the prior legal agreement. Either way, it really, the board has a copy of it. That's all I know. I'll gladly take whatever questions you have, but I think it's quite clear that there is a conflict of interest in having any of the three attorneys behind me ever represent our office. They are fighting harder than they have ever fought before to prevent us from having counsel so that they can continue to work with the plaintiffs that file suits to enter orders requiring us to produce documents and then paying them off with their settlement fee. And that's what's happened in two of the cases so far that we were not named as a party to. In Graham Media, they entered an order with Judge Servito where the prosecutor's office was not named as a party. They entered an order stipulating to the dismissal, granting them some money, and then putting a little provision in there requiring any county employee provide Corporation Counsel with the documents that were requested. Aside from that, the cases that did name the prosecutor in his official capacity as a party, there's a statute. It is MCL 49.73 that says when a county-wide elected official is sued as a defendant, the board shall, if Corporation Counsel or the prosecutor can't represent themselves, the board shall authorize and pay for an independent counsel. That's 49.73. It's the exact reason this board authorized Karen Springer to have an attorney when she was sued and named as a defendant, and that's exactly why the cases where the prosecutor is sued and named as a defendant in his official capacity, he is entitled, with all due respect, of course, I don't mean to tell the board what kind of authority they have, but with all due respect, I mean, the statute makes it clear. If corporation counsel can't represent us, which they can't because they're conflicted, and we've never heard anything from them contrary to that in the entire time that they were up here or in any of the memos, aside from, the quick, there's the prosecutor's office doesn't exist as an entity. Because they're conflicted, the statute obligates the board to respectfully provide independent counsel on those cases. So I'm happy to answer any questions you might have, but I would indicate as well that the Davis case, when Mr. Davis was here, that case did go on Monday. The case did name the Department of the Prosecuting Attorney as a party. The Corporation Counsel originally appeared in court and signed a stipulated order to dismiss on behalf of the Department of the Prosecuting Attorney, knowing full well that they were conflicted and knowing full well that we've told them they're not to be representing our office because of their conflict. That order was set aside by the court, and that's what we were in court for on Monday. So that's exactly what we were there in court for, and that's exactly why the hearing happened Monday, and then the court has set another hearing to follow up on that as well. Other than that, I would note that, part of the reason that Judge Font adjourned this past week was because she agreed with Chris Treblecock. He's from Clark Hill. He's here with us as well. He filed a limited appearance for the purpose of getting to court, putting our position on the record, and coming before the board to request counsel for that case. Again, because Department of Prosecuting Attorney was named as a party, and that order, the original court order has been set aside. We will come before this board, like you said, next month, and I don't mean to get any further into that. I didn't mean to sidetrack anybody on that. So, but I'm happy to answer any other questions you might have. I know that board's attorney is going to speak with you about the law, but I could go through each and everything. I just don't think it's necessary to rebut a bunch of legal issues when those are what we're trying to go to court for.
All right.
So I'll give you my opinion.
That's good. Thank you. Commissioner Gillette?
Thank you, Mr. Chair, and thanks, Josh. I guess my question's a little bit zoom out question. We've spent so much time, sorting through the minutia of what the law says and how courts work and who can represent who and so forth. I guess my bigger question is, why would the prosecutor's office want to represent itself with regard to FOIA cases anyway?
We don't. We want somebody who is unbiased and fair representing us. There are legitimate reasons why documents do not get produced in accordance with FOIA, because FOIA declares certain records public records, and then it accepts certain records from being public records. So we wouldn't provide the prosecutor, say, medications or his children's schedules, because those things are specifically exempt from the FOIA.
Yet
Corporation Counsel does.
Yet there was a fought in court to prevent what clearly are county documents, public documents, the check accounts. There was, the prosecutor fought to prevent those from being made public.
That's not what was requested. What was requested from us was bank records that we didn't have in our possession and that we didn't create, own, use, or otherwise rely upon, except for the 2 years of records that we did have, which we did provide. We granted the FOIA in part, provided 2 years worth of the records that we had, and denied in part because we didn't have any other documents. Our position is, and has been in that case, that the FOIA only requires us to produce records that we have, or that we can get from another public body here, another department in our county, sure. But to go to an independent, private, third-party bank, or anybody down the street who just happens to have bank records of ours, that's not what the FOIA requires. We have to give them what we have. And in that case, our position was we gave them what we have. We don't have the records from the bank.
So, thank you. So you're not requesting to have your own, to provide FOIAs through your department. That's a misunderstanding, because by I guess me and maybe some other commissioners, it sounds to me like you want a clarification as to who is the FOIA officer for FOIAs of the prosecutor's office.
Well, it's not that we want to respond to our own FOIAs. I don't think anybody really wants to go through the process of responding to their own FOIAs, but the individual departments of the county are the best, persons to respond to the FOIAs. That's why the Department of Public Works has their own FOIA coordinator. That's why the Sheriff's Department has their own FOIA team. So to get up in front of this entire board and have Corporation Counsel say, well, they're the sole FOIA coordinator and that they've been responding to FOIAs, this whole time, that is purely false. You can go to the Department of Public Works website right now and click their FOIA, website, and the link goes to their independent FOIA coordinator. We have a FOIA coordinator that's been appointed per our policy manual as early as back in 2011. I heard 2007. I haven't seen that one with my own eyes. But in 2011, our FOIA coordinator was the chief of our appellate division, Josh Abbott. And it has been. And he's continuously and consistently answered FOIA requests to our office. If we get a FOIA request that is for something outside of our office, we do what the FOIA requires, which is forward it to the proper department. In fact, the Attorney General's FOIA manual or FOIA, workbook specifically says that private parties may have to send a FOIA to a few different departments to get the documents they're looking for. If a FOIA request comes in for the county executive or for the Board of Commissioners and it comes to me, I will forward that to Corporation Counsel because I agree that if Corporation Counsel is the FOIA coordinator for the executive and for the Board of Commissioners, that's who should answer it. But if a FOIA request comes in for the prosecutor's, schedule from 2015 forward, and the prosecutor needs to be consulted about what's in there that is, in given the law about here's what is discoverable under FOIA and here's what is not, then that prosecutor needs to be able to look at those records and say, this is personal. The medication I take and when I take it, just because it happens to be on a government schedule or my Google schedule, doesn't mean that it's discoverable under FOIA. So to give that record away or to give that task away to Corp Counsel, I was happy to send any FOIA request to Corp Counsel that we could when it didn't involve records from our office. And that's what we would do. But when the records come to our office, they go to our FOIA coordinator. And that's what the FOIA statute says. The FOIA coordinator it could be the county, but it's also any public body or any agency of the county. And it makes sense to say the chief administrative officer for those public bodies is the FOIA coordinator. So our public body would be the Department of Prosecuting Attorney. Eric Smith is the chief administrative officer. He's therefore the FOIA coordinator, and he appoints, Josh Abbott, who is our chief of appeals, as his FOIA coordinator. And then that's how that works. In the county itself, again, if the statute, by statute, it says that the chief executive officer, Mark Hackle, for, the county executive's office, Board of Commissioners would be the chairman of the board for that individual public body. That's what the statute says. And to sit here and go back and forth and argue on it, I don't think is something that, that's going to be our argument in court. That's our legal argument. And it has been our legal argument.
Okay.
And they simply disagree.
Yeah.
And that's what we want to go to court and find out.
Okay, and I appreciate that answer. This might not be your area, but how should we respond when Corporation Counsel states that we can't even hire anybody without it being a contract, and the contract requires the signature of the executive and approval by this board. So even if we agree to all three or one or whatever it is of the terms, that it won't matter because they're not going to pay them.
Well, I think we take one thing at a time here to assert that the Department of Finance isn't going to be allowed to pay for something where there's a legitimate and valid resolution from this board with a legal contract. Clark Hill has provided me with a written retainer agreement. I'm to provide that to the board when I make a request for independent legal counsel, the same way I did with Howard & Howard. When I provided that contract to the Board of Commissioners staff, that is the retainer agreement for exactly what the board authorized. That's the contract that comes in front of this board, and it's a services agreement. It doesn't go through the exact same procurement ordinance as general services contracts. It's a professional services agreement, excuse me. They don't go through the same way as a regular services
Right, I know that, but don't they still require the signature of the executive?
Yeah, and frankly, if you grant me an attorney, I'll ask him. Because that's the spot that we're in. We're essentially forced to answer legal questions from, you know, from ourselves when just like John said up here, he's not an expert in criminal, and I'm certainly not an expert in all things county. And frankly, without giving us an attorney to consult, we have to stand here and ask three people who at least have shown that they are completely adverse to our position, regardless of what it is.
So my final question, and I've gone to probably a lot of other people, is would it be your contention that the legal corporation counsel is essentially disqualified themselves from interacting with the prosecutor's department on any capacity, whether it's FOIA or anything else?
Just as representative, just as a legal representative. I mean, that just means that they can't represent us legally. We don't need them to represent us for FOIAs because we have our own FOIA coordinator, just like the Sheriff's Department, Department of Public Works, and anybody else who doesn't delegate that authority over to Corp Counsel, I guess. So when we get sued, or when somebody from our office gets sued, right, Corporation Counsel has, by suing the Department of or by suing Eric in his official capacity, they have now, created this conflict that, is irreparable. And that's not something that we created. And in fact, when this first came up, it was they were going to represent us in the Maynard case. But one of the attorneys from Corp Counsel expressed a desire to access documents in that case to push what was going on with the treasurer at the time. And that wasn't something that we were interested in getting involved in. So it was a simple FOIA lawsuit, which is typically a motion. Hey, I requested stuff from FOIA. They denied it. Judge, will you tell us whether or not that was proper? I mean, frankly, a civilian a non-lawyer, non-government official can go represent themselves in a FOIA just for that limited basis. The problem is that's not what's happening now. Now you have Corporation Counsel essentially teaming up with plaintiffs as they come in and, joining forces with them and trying to get what they can out of whatever judge they're in front of.
Okay. Well, thank you very much, and thank you, Mr. Chair.
You're welcome. Commissioner Kleinfeld?
Okay, a couple of things. Let me make sure I understand your position with regard to that FOIA. You only kept the records for 2 years. Is there a county policy? I don't know if it's written. I know that there's a standard of about 7 years, but I don't know if there's a written policy on that or not.
The county has not issued a written policy.
Okay, but it's a standard of 7 years. So your position is, if you wanted to get those bank statements and throw them away a week later and only have a week's worth of records on public funds, that would be an appropriate thing to turn down a FOIA on because you only keep a week's worth of records?
Absolutely not.
Well, where do you get the standard that they're only public documents so long as you've kept them, and the second you throw them away, the funds that were public funds are no longer, the public documents are no longer public because you've thrown them away?
That's not what I said the standard is. First off, the Department of Management and Budget for the state of Michigan puts out a records retention schedule. And that records retention schedule applies to all local government bodies. And then they get specific schedules for prosecutor's office, sheriff's departments, city police departments. And in that records retention schedule, for forfeiture cases, it requires that we keep all files from forfeiture cases for 2 years. So we maintained our forfeiture records for 2 years. Okay,
that's the minimum that the department requires, correct?
That's the minimum. That is the state required amount of time to maintain records.
That's the minimum amount that the state requires.
I agree with that. I agree.
Okay. You indicated, again, the question is whether or not you're a public body. First of all, legally, if I understand, the reason departments get dismissed from cases all the time is because they aren't their own entity, and they aren't their own public body, number one. And this is what got us here to begin with. The whole thing about your being your own public body, in 2015, the prosecutor told us he doesn't have those funds going through the county because he's his own body and he reports directly to the state. I have a tape of that, by the way. He was asked if those funds were audited. He said that's up to the state to make that determination. I believe that part of it, whether or not you are your own public body that gets to keep your own records and they don't have to be audited and they don't have to go through the county, I believe that part's all been settled. I don't think you need an attorney to settle that, because I think we are where we are today because that was the position of your department. That may be a lone commissioner's position on that. But
Oh, I think, if I may, you're talking about two separate things. Public body under FOIA is one thing. Whether or not, you know, the forfeiture statute said what they said is completely different. What we're here for today has absolutely nothing to do with anything having to do with the forfeiture funds, the ongoing audit, anything. It's completely and entirely separate. There's no dispute that, that the prosecutor's office is a public body. No dispute under FOIA. Everyone knows, everyone agrees that that's the case. Whether or not we as our own public body can...
As your own public body, so what you mean is your own public entity. What you mean is...
That's not true. Because that's not what I'm saying. A public body is defined under the FOIA. And under the FOIA's definition of public body, we are a public body. Our position is, because we are a public body as defined separately under FOIA, the FOIA allows us specifically to appoint a FOIA coordinator in that specific public body.
Aren't you a public body because you're part of the county entity? If the county didn't exist, would you as a public body exist by yourself?
No, we would not.
Okay, so you're a public body that is part of the county.
Right.
You're a public body because you're part of a larger public body.
We are a part of a county, yes, that is right. That's what the FOIA says.
Okay, thank you.
Keep in mind, he's going to be back up for his request, but does anybody have any other questions for him right now as it relates to this correspondence that we got from Corporation Counsel? Commissioner Haw?
Thank you, Mr. Chair. Just one quick request. You talked about court on Monday. Did you represent the prosecutor?
I did not. Mr. Treblecock represented us from Clark Hill.
On Monday?
On Monday, on a limited appearance for the purpose.
I don't want to hear that limited, unlimited. He represented the prosecutor on Monday.
That's right.
And that's the one that we just changed to?
That is correct. The amendment to the original request when it first came through our system was for Pizer. I received a notice that they wanted to make one slight amendment on what was presented here. They wanted to add more things. I said, no way, you're going to have to wait, no offense. But they did add that they wanted to change to have Mr. Treblecock instead of Mr. Pizer. And we did amend that in our when we adopted the agenda. Yes.
Was the first agenda Clark Hill or was it Howard and Howard?
It was Mark Pizer. It was the first agenda.
But there was a name and a company, right?
Correct. Yes. Well, it wasn't a company. It was Mark Pizer. Is he from?
It did say Mark Pizer at Howard and Howard.
Yeah, I'm sorry. Yes. Yep.
Okay, thank you.
You're welcome. Anybody else? Okay. We're going to close correspondence, I think. I think we've covered that. And at this point, the next item on the agenda would be to move to a closed session. Okay. Got support by Commissioner Lucido, support by Commissioner Majak. Please vote. Before we go into closed session? All right, hold on. We have a motion. However, we have some discussion. Chairman Smith has some discussion before we vote. Go ahead.
Listen, I just want to talk. There's been some conversation about me not being in closed session. I'll tell you that I'm going to be in closed session because I believe that this is an issue of whether the board has a right to do something or not to do something. And we're talking about legislative authority. So I'm just saying that I'm going to be participating in closed session on that agenda item only. If we get into items other than that, then I'll excuse myself.
Yeah, go ahead.
Just for clarification, though, he keeps using the word recuse with respect to himself. He's abstaining on votes. No, you did earlier in the meeting. You specifically said you have recused on the vote. You're abstaining on votes, but you have not recused on the situation. There has been some confusion relative to that, so I just wanted to clarify that. You're abstaining on votes, but you haven't recused from anything to date.
So my recused from anything does not recuse. I never wish to recuse myself from what I think is a board legislative duty versus an executive duty versus what's really happening in the realm of government in the county. So you're right. I will not recuse myself on those.
I'm not trying to debate you. There are commissioners that thought you were recused, and I was just setting the record. You're abstaining, but you are not recused. I just wanted to set that record straight. Thank you.
Okay, there's a motion on the table. Please vote. Passes 11-1 with Commissioner Kleinfeld voting no to go into closed session. All right. All right, we are now back in open session. We are going to go to item number 9, which are department recommendations. We're going to take these individually, A, B, and C. Now, Josh, I assume you're going to come up here and talk. Is that correct? Okay. Yes, briefly, just briefly. We're going to start with 9A. Yeah, yeah. Just 9A. Come on up here and make your pitch. Yep, make your pitch about this one here. Yes. Yeah, the Maynard case.
So the only issue with the Maynard case, I just want to clear up what was said earlier. I certainly filed a pre-answer motion in the lower court. There's no default that was entered, anything like that. In fact, the judge actually entered a final order before the time for filing my answer even ran. The other thing is because the judge entered a final order in that case and the prosecutor is a defendant, that gave us a claim of right to appeal. So the only thing I had to file in the Court of Appeals to preserve our appeal is a piece of paper that says we intend to appeal. And the reason nothing's been done with it so far besides ordering transcripts is because I needed to come before the board to seek counsel to move forward with it, or at least to consult with about moving forward with it. And that's where we're at now with the Maynard appeal.
Okay, these are questions. Okay, now look, we're going to make this quick. These are questions regarding only A.
Right, and actually I meant to cover that too. So the other thing is it is not moot because they're completely correct. Is we can't go back and get the documents back. It has nothing to do with that. The issue is the Judge Servito in that case ruled that we were required to provide documents that we didn't have in our possession on the basis that they were financial records under the Constitution. It really wasn't. He kind of went outside of FOIA to it, and he ruled that we can have constructive possession of. It doesn't matter. The bottom line is, we don't want to have to be required to provide to go to private third-party companies or persons to obtain documents as part of FOIA, and that's what Judge Servito essentially ruled. And so that would be the challenge. And again, after consulting with legal counsel, it may be amended or revised, but we certainly won't be bringing the who has the right to answer FOIA as part of that suit or anything like that. That's not what that case is for.
Just as a point of information, I'm not going to argue your case for you, but just to add something else, because it was a final order and because the judge perceived you should have had constructive possession, there were costs awarded to the attorney in that case. Those were county dollars that went to the attorney because the judge's decision was you guys should have produced these things. So there is somewhat of an appealable issue there, and if you're thinking on your county commissioner hat, there were county dollars that were expended to an attorney because it was perceived by the judge down here that the prosecutor didn't come through with it. So just to add that.
And just all of that is correct of what happened. I will tell you that the judge did order that, because the county didn't actually respond, Corporation Counsel never responded to the FOIA request despite receiving it. We did. And so the court ended up bringing the cost issue in with the county's argument, and the county ended up stipulating to those costs. So in fact, every case, the Corporation Counsel has stipulated to the amount of attorney fees.
Okay. Questions in regard to 9A for Josh? Seeing there's none, let's call it to a vote. The issue is going to be whether or not I'm looking for a motion to recommend the full board authorize the prosecutor to retain Christopher Trelleblack from Clark Hill at a rate of $250 per hour as independent legal counsel to represent the prosecutor in the Maynard versus County of Macomb et al. Court of Appeals case to be funded by the county's litigation fund. That is a motion that I'm looking for. Okay, so motion by Romano, supported by Brown. Motion on the table, please vote. Okay, that motion passes 8-3 with one abstention from Chairman Smith. I'm going to move on to the next item, which is 9B. Josh, come on back up.
I don't know much about this case because we haven't been involved in it. This case is really through most of the appellate process. It honestly looks like it has an oral argument remaining. I'm not entirely sure because I'm unfamiliar with the case. I'm not even, to be honest with you, I'm sure that a quick review by legal counsel into the facts of the case would probably cover this entire case. If this case goes anywhere else, it would simply be to an oral argument in the Court of Appeals. So there is not a substantial cost involved with this one. I just don't know anything about the case because the Corporation Counsel has the file still. So,
Josh, I appreciate your honesty, and the fact that you don't know not about it might mean you don't necessarily need an attorney. Is that correct?
Well, no, we certainly will need somebody to represent our interest in the Court of Appeals because, just so we're clear, there was another case that when Corporation Counsel saw that we were going through with requesting counsel on these cases, they then stipulated to dismiss one of the appeals in the Donald Williams case. So I really don't know what's happening behind closed doors. I'm sorry.
Let me just say this as a point of information. I've done some of my research. This case, just so you know for the board, with what information I have, this is a case where a gentleman is upset that the county as a whole has not arrested his brother. He has filed a lawsuit against every single person, Hackle, the prosecutor, the sheriff. His pleadings are frivolous. I mean, I'm just telling you that it's comical. If you want to read them, go ahead. But it has nothing to do per se with the county prosecutor individually. He's named, the prosecuting department is named, so is Hackle as the county executive, and so is the sheriff. But the merits of this case are just way out there for point of information. Yeah.
Just as with all three votes, any no votes do not necessarily mean that the commissioner is voting no because they of any question with regard to our authority to do so.
That's correct. That's correct. And keep in mind, these are just sending them to full board too. Plenty of time for you folks to look at your. You could reconsider it, and when we come back at full board and have more information, you can always.
I just, even if I stand on a no vote, it doesn't necessarily mean that I am capitulating that I don't have the authority to vote yes. I am not necessarily saying that. I just wanted to say that for the record.
Thank you, Commissioner Kleinfeld. Good point. Okay, any questions for Josh? All right, let's put it to vote. I need a motion here to recommend the full board authorize the prosecutor to retain the.
This particular one, I'm not warm and fuzzy about, but being that he didn't know enough of the information, is this something that should be tabled? I'm asking because there could be some legitimacy. Right now, he can't answer one question on this.
It was so important to have someone here to know.
Okay, all right.
Are you good? That was a good point. No, I get it. I get it. We're going to look for a motion. If anybody wants to make a motion to recommend the full board authorize the prosecutor to retain the gentleman from Clark Hill. Okay. All right. Is a motion to deny support from Commissioner Drollet? Motion to deny is on the board. Please vote. You vote yes, you're going to deny this request. Okay, 11-0 that this be denied with Commissioner Smith abstaining. Now we're going to move on to 9C. Now, Josh, let me caution you here. You don't have a lot that you need to say on this. A lot of what we've been discussing this ad nauseum. We kind of know what your position is. This is a big issue. You can give maybe a 1-minute pitch if you want, but at this point, we're pretty informed on this one issue.
I am very comfortable that Mr. Webster has informed you on everything you need to. So I'm certainly here to answer questions. I don't mean to shulk any duties or anything like that. I just want to make sure that I don't have anything else to say. I already talked too much as it is.
Do you have any questions? I have one question for you. You can just briefly talk about this. Do you think there would explain to us what your harm would be if we delayed giving you an attorney on this? Because this is an affirmative action that you're wishing to take. You're not in court on this. The other two you're already in court on. This is an action, if I understand correctly, where you're going to be going to court on it. What would be the harm if we delayed in giving you that option today?
So right now, one of the cases that are not up, and I'm purposely trying to avoid talking about Mr. Davis's case because it's not up, but since he's here, I will say that by granting the third portion today with Mr. Davis's case, and with Mr. Treblecock already being on that case as far as his limited appearance, it would allow us to bring these issues in the current case without initiating a whole new complaint, without initiating any other, I guess, additional fees or costs, because we would simply move to intervene if the judge is going to vacate vacate the Department of Prosecuting Attorney as a party. Without getting too much into the legal sense, it would say the harm that could be caused is, A, we wouldn't be able to intervene in a case where we have already had corporation counsel act like they were our attorneys, appear on our behalf, and dismiss us from a case.
One thing, Josh, that case isn't in front of us yet. So I get what you're saying, and who knows what we'll do on that case, right? When that case comes in front of us,
correct,
we may give you the attorney you're looking for to deal with the issues of that case. This is more of a global request. This is a request to say, I'm going to sue the county to figure out what the policy is with respect to FOIA. So this is more of a global request, if I understand it in your request here this afternoon or evening now.
That certainly is how it would have come across absent Mr. Davis's suit. Because we have Mr. Davis's suit where these issues are already being addressed in front of the court, we now just need to be able to represent our interest in court. So while this would have been like kind of like a global suit where we sit down and talk about how we're going to bring the case, now the county's already in it, Mr. Davis is already in it, and the Department of Prosecuting Attorney is already in it. We just simply need to assert our position. And if the judge's order vacating or dismissing the Department of Prosecuting Attorney stands, we can accomplish everything we wanted to accomplish in this suit. It would make it far less complicated. I'm guessing less, I don't know, I don't get the attorney bills, so I'm guessing less costly, but it certainly would make things less complicated when we're already all parties to it. So by delaying, essentially what we're doing is waiting for the statutory provision to kick in that says the board would be obligated, to give us counsel when our request for counsel in Mr. Davis's case comes forward. If what's going to happen is we simply need to wait for Mr. Davis's case to be presented in front of the board, we will have to go in front of the judge and inform her obviously that the board has yet to decide on this case and push it back. And I already know that Mr. Davis's counsel has filed 2 separate motions that are labeled emergency and has been trying to expedite the case for various reasons. So the harm cause is really more of, it's a lot easier to do it while you already have a pending case, and we didn't have a pending case that we could necessarily assert it on before, except for the Valerie Note case in which the Corp Counsel dismissed all of the charges at issue.
Question done? No? Okay, good information to know. Understand procedurally, what we do here now is just whether or not we forward it to the full board or not.
Understood.
Okay.
Understood.
Right. Okay, so there's a motion to approve. Is there support?
I'll support.
Support by Commissioner Brown. Is there any discussion that we want to make before we vote? Okay, Commissioner Carabelli.
Mr. Chairman, I thought I understood what this was for. No, I'm being honest. I thought I understood what this was for, and I thought the opportunities to do something else was the right thing. Again, trying to understand all this, I have no problem right now, the second for approving this and giving it to full board for me to make the opportunity to have another bite at the apple, because this just threw a big loop into what I thought I was going to be doing. I don't know about the rest of you, but this threw me for a loop.
Sir, you're not allowed to talk. You can talk in public participation, so just keep your hand down. Not being rude, just you don't have to. You can't talk into public participation.
Good. No. So this one, at first I was not in favor because I wanted to take another action. Now, give me enough time between now and full board for me to have an understanding of what he just said, because again, I'm not an attorney and it's all over my head. So just.
That is correct. You would not, if you vote to approve this motion, doesn't mean you're going to give him an attorney, because we still got to do that at full board, and that does give us time to figure this out. Because I do agree, it does throw a little bit of a loop of what our plans were, and there's already an existing case that's going to be coming. I kind of regret perhaps not putting that case on the agenda today. I just didn't feel it came timely enough to us per our procedures, and we can certainly add that to our full board if we have to. You know what I mean? So okay. Anybody else? Veronica?
Yeah.
Commissioner Kleinfeld?
And we're going to deal with it on full board, but I just want to remind everybody, if a judge sides with the prosecutor's office, the prosecutor will be in charge of their own FOIAs. If the judge sides with Corp Counsel, then the county executive will be in charge of the FOIA decision making. Just want to remind everybody of that statement.
Point. Go ahead.
Just indicated his intent.
Let it go. Let it go to full board. Folks, we still have what we discussed in closed session. That is still an option on the table. Let's just decide if you want to give this a chance at full board. Okay? We got a motion on the table. Does anybody else have any discussion? If not, we're going to vote. I don't know about you, but my screen's looking like the Predator movie. I don't know what's wrong with this thing.
Commissioner Romano, did you save your vote?
Okay, this passed to move to full board. I'm going to caution you and the gentleman that's back there, this doesn't mean it's necessarily going to go through. We've just moved it to full board because of the fact that there was a little snafu. We need more information. And the motion, I think, passed. I lost the screen. What was it again? 9-2 with one abstention. Who voted no? Kleinfeld and Leon. Okay, fair enough. Okay. All right. Okay, thank you very much. We're going to move on. Thank you very much, folks, for coming. Appreciate it. We're going to move on now to new business. Do any commissioners have any new business? Okay, Chairman Smith.
I apologize for having new business, but Yoga at the Hill, do not forget this weekend is Yoga at the Hill. And also, the Bernstein group wanted to come in and inform us on the opioid lawsuit. That being said, their time didn't coincide with any of our meetings. The only time they can really come in that looks any good is Thursday, 6/13, which is next Thursday in the morning at 9 a.m. I can do it as a informational group if we're not going to have more than 6 commissioners. If 6 commissioners or more are interested, we'll put this up as a meeting to have them. Well, no, I need to know if people are going to show up, right? I mean, so next Thursday morning at 9 o'clock, Bernstein, or we can have them just give us, whoever wants the update, and then we can send out the information to everybody else. Want to just do it as an informational one? Okay. And then Harold will take it too, because you'll be here. No, you'll be here for the meeting, your pension. So we'll both be here. How's that? We'll both get the information. All right. Thank you, gentlemen, ladies.
Anybody else have any new business? If not, I want to just remind everybody we're going to move, and we can bring these other cases up. Because of the jail situation that, believe it or not, that could have been on this agenda. Can you imagine that today? So thank God the information, as indicated, they needed some more time for information. So we're going to put it on the Wednesday 19th. I'll see you, Bob. We're going to put it on the Wednesday, June 19th meeting. We're going to add in records and public services to give the jail a chance, the sheriff to come in here and present his issues with the jail. We can also add this case that we were talking about here as well. And then we have full board the following day. So, if, again, I brought this up before at another meeting. I don't think any has. We can do mine at 2 o'clock, and then we have joint internal public services, and then we have another one. So we can take care of 3 things on the 19th. Anybody have any objections to that? Okay. All right. Good. Gotcha. Okay. Without any other new business, we're going to close that. We're going to go to public participation. Sir, it's been a long day for us, but you got 5 minutes, so just No, I can't do that. I can only give you 5 minutes. I'm sorry, sir.
Your agenda indicates at the discretion of the chair, so
yeah,
all your other speakers have more
I'm
than
only
5
going to give you
minutes.
5 minutes, sir. I wish I could.
Let me state this for the record. And that counsel that just stood up just committed an egregious violation of his barcode because he just lied to this body in an effort to try to lie in front of Judge Fonts. The Department of Prosecuting Attorney has been dismissed from my case. Under the court rules, counsel, as you should know, a plaintiff has a right to voluntarily dismiss any party prior to an answer being filed. That occurred in this case with respect to the Department of Prosecuting Attorney. It's 2 separate dismissals that occurred in that case. One that Judge Fonts signed dismissing the department, as well as a voluntary dismissal. Judge Fonts did not vacate the dismissal of the Department of Prosecuting Attorney from that case. Look at the court file. Secondly, and I understand what's going on here, which is going to lead to even more litigation against this county. I'm glad you clarified that your vote today was just a recommendation to the full body for a full formal vote. And so that it can be reported to Judge Fonts on Monday that your vote here today did not in any way authorize the hiring of Mr. Trebelcock and his law firm to intervene in my case, which you did not vote on this evening. Is that correct, Mr. Chair?
I can't answer your question, but the answer to the question is, I can't answer. I'll talk to you outside. I'll talk to you outside.
Well, I just want the record to be clear that this body did not authorize.
Listen, you seem to be a smart guy.
No, I'm
going to just say this. I can't even talk. We don't converse
Well, I'm not trying to debate back and forth, but I just want the record to be very clear for future proceedings. But additionally, I want the record to clearly reflect that certain misstatements were previously made by the representative from the prosecutor's office, as well as, I believe, by a member of this honorable body. I did not make a mention of a misdemeanor. I made a mention of misrepresentations that were made to the judge by Mr. Trebelcock on behalf of the Department of Prosecuting Attorney at the Monday's hearing. What he represented to Judge Fonts was that this body tonight was going to approve his appointment as counsel in my case on behalf of the department, not on behalf of the individual prosecutor in his individual name, so that the record is very clear that you have an attorney that has entered an appearance unlawfully, which will be reported to the bar, as well as the Judicial Tenure Commission has been placed on notice on certain ex parte communications that occurred between the Department of Prosecuting Attorney and Judge Fonts, which this body should also be cognizant of.
I'll give you a 2-minute warning.
Thank you. And so that we are very clear, my case is only with the County of Macomb, period. Not with Eric Smith as an individual, not with the Department of Prosecuting Attorney. And again, to be clear, the Department of Prosecuting Attorney was properly dismissed from my case, both by stipulation, by order entered by Judge Fonts, which has not been vacated, which was falsely stated by the representative from the prosecuting attorney, as well as it was voluntary. They were voluntarily dismissed by notice per the court rule. So they're not a party at all. So what you just tried to approve was a flawed attempt to try to backdoor what's going to be inevitable, which is the fact that the documents that were requested under FOIA will be disclosed. And so that you're perfectly clear for all of the board members, because I heard a lot of discussion, and that's why I was raising my hand, because I could have made clarification at that point when individuals were making false statements.
50 seconds.
That's all, Mr. Chairman.
Thanks. Thank you very much. All right. Any other public participation? I didn't think so. All right. We're going to close it out. I need a motion to adjourn this one. We're going to give that to Commissioner Brown because he's got seniority, and we're going to give it to Commissioner Sauger for a second because he's got seniority.